Namaste and very warm greetings from Team The Indian Lawyer to yet another episode of The Indian Lawyer Legal Tips. I am Sushila Varma, Chief Consultant at the firm, and today's topic would be of interest to many. That is, why did Arvind Kejriwal get his bail from the Supreme Court of India? Now, before we go any further, I think we should discuss what is the excise policy that came under the scanner. To put it very simply, the Delhi government had started a new policy called the Excise Policy 2020-21. In this policy, the government had changed several aspects of the liquor licenses by which a few private individuals were going to get huge profits as a result of the kickbacks they had assured government officials. Because of this policy, many people came under the scanner. First, the lobby of businessmen who were going to make huge profits, and secondly, all those politicians and officials who had actually formed the policy which was going to favor these businessmen. As a result of which, a number of arrests took place, amongst which people Arvind Kejriwal was one. Now the next question that comes to our mind is, who were the notable people who were arrested? Since there were a number of people, we are only mentioning some of the prominent ones on the screen below. Now let us understand what was the defense taken by Arvind Kejriwal's counsel in the Supreme Court of India while asking for his bail. The first defense that the counsel for Arvind Kejriwal took was that the arrest of Arvind Kejriwal did not follow the procedure that was laid down in section 41A of the Criminal Procedure Code. Which mandates that a notice has to first be served before any person is arrested. Secondly, the counsel also argued that the arrest was arbitrary and was violative of the provisions of law, and also it violated the conditions set by the Supreme Court of India in the judgment of Arnesh Kumar versus State of Bihar 2014 judgment. Another reason taken by the counsel for Kejriwal in his defense was that Kejriwal's name was not mentioned in the FIR and there was no new evidence on the basis of which he was arrested. The counsel further argued that Kejriwal had always joined the investigation and had cooperated with the investigation, and there was no requirement for him to be in custody when he was answering the queries. The counsel further argued that all documents that related to this particular crime, that is the excise policy, had already been collected by the ED and the CBI, and as such, Kejriwal's presence in custody was not required. To this, the ASG, who was arguing for the ED and the CBI, was of the opinion that there was no requirement for serving notice while arresting Arvind Kejriwal, as he was already in judicial custody. He further argued that Arvind Kejriwal's presence in custody was necessary in order to confront him with crucial evidence and to understand or uncover a wider conspiracy that was there, which could not have otherwise be uncovered by the CBI and the ED. Now let us understand what the Supreme Court of India had to say regarding the validity or legality of the arrest. The Supreme Court of India was of the view that the arrest had not been made illegally, and what the ASG had argued that since Arvind Kejriwal was already in judicial custody, there was no requirement to serve a special notice to him before he was arrested was absolutely correct. So based on this, the point on his arrest being valid, legal and binding was upheld by the Supreme Court of India. Now let us understand why the Supreme Court granted Arvind Kejriwal his bail despite being in agreement with the ASG that his arrest was legal and valid. The first reason I would say was because the court felt that there was prolonged incarceration, that is, he was behind bars for a very long period of time, and the court felt that since the trial would take a very long time and there were so many witnesses and documents that had to be examined, his being in custody would serve no purpose. The court also felt that keeping Arvind Kejriwal behind bars for such a long period of time is violative of his right to freedom under Article 21 of the Constitution of India. Another reason for giving Arvind Kejriwal his bail was because the Supreme Court had applied the triple test for bail, which is first, whether the person poses a risk of flight; secondly, whether he or she will tamper with the evidence or the witnesses; and thirdly, whether the person has criminal antecedents. The court felt that since Arvind Kejriwal did not have criminal antecedents, nor was there any likelihood of his leaving the country or escaping from the police, and thirdly, that since he had not tampered with any evidence and the police had already, the CBI and the ED had already collected a large amount of evidence, they did not feel there was any reason to hold him any further. One of the main reasons why the Supreme Court was ready and willing to give Arvind Kejriwal his bail was that the Supreme Court felt that he was always cooperating with the investigation. To this, the ASG argued that all the answers Arvind Kejriwal gave to the ED or the CBI were evasive and were not conclusive. The Supreme Court felt that just because the answers were evasive, it could not be a ground for holding him indefinitely in custody. Apart from this, the fact that there were other people who were also involved in this scam were given bail. So the court felt that on the basis of the principle of parity, Arvind Kejriwal should also be granted his bail. And finally, the court applied the judicial principles of liberty, which state that one cannot be in custody for a prolonged period of time if there is no reasonable timeline set for the trial to be concluded. And the court felt that in this case there were too many witnesses, too much of documents, and there was no likelihood of the investigation concluding in the near future. Another very important aspect of this case is, or question I would say, is why was Arvind Kejriwal arrested under the Prevention of Money Laundering Act? The answer is that Kejriwal was implicated in a separate investigation by the Enforcement Directorate under the Prevention of Money Laundering Act, even though he was not named in the FIR, for the alleged use of the illicit proceeds that they had gained from the liquor lobby, and this particular proceeds was actually utilized by Kejriwal in the campaign in Goa. And based on this finding, he was arrested by the ED and he was found to be guilty of an involvement under the Prevention of Money Laundering Act. Now let us understand the logic of the Supreme Court in granting bail to Arvind Kejriwal. The Supreme Court's logic is that the judgment was rooted in ensuring procedural fairness to a person even though he is an accused. The court further felt that though the arrest of Arvind Kejriwal was legal and cannot be challenged, yet the delay in the trial, which could take probably years at a stretch, did not particularly favor the fact that Arvind Kejriwal should be in custody. Keeping this in mind, the Supreme Court decided to keep a careful balance between the rights of the accused and the needs of the investigation, and therefore granted Arvind Kejriwal bail on certain stringent terms. The said terms are reproduced on the screen below. Dear viewers, before signing off, I would like to dwell upon a very important judgment of the Supreme Court of India, which is known as Arnesh Kumar versus State of Bihar 2014. In this judgment, the Supreme Court had held that when an accused has committed any offence in which the punishment is less than 7 years, the arrest must be made by a police officer only if he is satisfied that such an arrest is necessary. The arrest would deem to be necessary if the police felt that the accused would commit another crime, or that he would flee from justice, or that he would tamper the evidence. If these grounds are not found by the police officer, it is not necessary that the accused has to be arrested. If you have found this video useful and you feel that yes, you can share it, please like, share and subscribe to our channel so that we can make many more such videos which is in the interest of the general public. Please note that these episodes are only legal tips or report on matters which are trending or controversial. They cannot be deemed to be legal advice, and as such, whenever you are in any problem, you have to approach a lawyer with your documents to get the correct legal advice. With this, I sign off and I say Namaste. See you again next week with a new episode. Thank you.